You got the recording started. And today I'm going to start with the Internet Law, which is our module 4, the last one. And I would like to start with the intellectual property, which is really very important for the research specialist to have a good understanding of what type of data you could use, or what could be intellectual property restraints as far as legalities for its use. Um, well, the first topic would have been the jurisdiction, but that is not as it is not as extensive. It is more definitions in there. So let me just see if I can get started with intellectual property first. I have this slide in front of me. This is defining three types of intellectual properties. There is copyrights, there is trademarks, and patents. Patents, we are not going to go very deep into this because patents are really one area which, depending on whether it's going to impact your research work or not, we're going to put them as least priority because patents are not something that you would be infringing much, or you wouldn't come across a patents issue as much as you would with copyrights and trademarks. So more emphasis on copyrights and trademarks, less on patents. Now, what is copyrights? This is by definition, it protects original expression in the literary, dramatic, musical, and artistic works. But it is not a complete definition. Copyrights can be anything that is genuine or original, that is a work produced by someone through efforts, and it has the original tone to it, like it is created by someone's um, creativity, you could say. So we will look at what is typically considered to be copyrights protection. Now, copyrights means, first of all, let's look at some of the examples of copyrights so that it's clearer. Let me see. Where is it? And you're most welcome to ask questions on copyrights if you like, in between, or you can put it in the chat. Where is the copyrights definition? Should be in one of these. So copyrights are generally, when you're writing an article or you are an author of something, it could even be softwares, which is also intellectual property and is considered IP protection. And there is plays and films and songs and paintings and so on. Even original work that you do on a diary, even if you write something on a piece of paper, the moment you have written it, even though you may not have published it, the copyrights automatically belongs to you. So copyrights is something that you don't really always have to file for because there are so many writings one does on regular basis, and you don't actually go and file them somewhere in the registrar's office. Basically, within the US and in Canada, there are these government uh, um, uh, we could say that government offices which exclusively deal with the copyrights um, that are to be registered, or wherever you would like to file them in a formal way, you will have to apply it through these agencies. In Canada, we have Intellectual Property Office. Similarly, in USA, you have the copyright offices as well, that is run by the government. The way the copyright works in US and in Canada is that you just upload your work onto those government sites, and even if you have given a title to it, that should be sufficient. But those copyrights are filed for the naming or anything that you have, you have a title for. But if it is a book, for instance, then you can upload the entire book as an attachment when filing it online. There is a fee that you have to pay to the government agencies, which is basically, very nominal fee. But they don't actually exclusively ask or commit to keeping records or archives of your entire copyrighted work. Um, for instance, if it is a book that you wrote, you can just write few things about the book, what the book is about, the title of the book, that should be sufficient. But there are other third-party agencies which are experts in archiving those or keeping records of those intellectual property documents. And those uh, archives are generally considered to be, not to be the third-party agencies, which can be even, where you can actually look for the copyrighted work as an evidence when you need it, or if there is a litigation happening in this area, you can ask those archives to present them as evidence or to make them available as evidences. The what copyright allows you to do is that you would get these rights, which are listed here, the rights to reproduce the work. You have the right to make derivative work out of it. You have the right for distribution, the right for public display, the public performance rights. Now, infringement happens when you have these rights when somebody else is using it other than yourself, or claiming to have rights to it, or is making derivative work on top of your copyrighted writings or copyright work. The infringement happens in, or by law, there are three different types of infringements. Generally, one is called direct infringement, the other one is contributory, and the last one is vicarious liability or vicarious infringement. Direct infringement is outright just copying somebody's work and claiming that it is yours, which is direct infringement, where you have actually started to use this work as a reproduction, or you're distributing it without permission of the actual owner. So that is direct infringement. Contributory infringement means that you are not the direct infringer, but there is another party in between, which is the, which could be the, um, you know, um, somebody else that gave you that work for use, and you as a user of that original work, without verifying it through the actual author, have started to use it, even though you have not obtained it directly from the original owner. So that is contributory infringement. Vicarious infringement means that you are somewhat a part of the chain where the actual work is moving from one party to another, where in between one one of them may not even know that they're infringing somebody's work, and they assume that it is that it is in the public domain. Yet, by the time you get it from that source, you are also not aware if that work is originally coming from that source as the author of it. And at the same time, sometimes that person who has given you that copyrighted work also may not be as aware of whether or not it is reusable. So the vicarious liability happens when, we call it like lost in translation, where you won't know if it is original or not, and the few parties in between that move the word or that transfer the work from one party to another may also not be as aware of it. So in a situation of vicarious liability, the court is a bit lenient, and you don't have to pay the full damages on account of the fact that you had assumed few things, or you were given the impression that that originator of that work has allowed you to use it somehow. So the liability factor or the damages is reduced in vicarious liability. But at the same time, the law in vicarious liability also puts a responsibility for someone actually using it to verify it as an original work. So there is no actual real escape out of vicarious liability, but the damages might be less compared to the direct infringement. In the exams, we would get a question on copyright infringement, and there could be case laws, or there could be, an a situation given to you, and you would have to figure out whether what type of liability is this infringer accountable for. So that's the typical question that would come. So a good understanding of direct versus contributory and vicarious liability is important. And we will do some examples based on the copyright infringements. Internet related infringement that are also under the domain of copyright infringement comes in different forms. We have discussed as examples for the online information for reuse, that includes piracy, caching, page linking, and within page linking, there is deep linking, inline linking, there is framing, linking to infringing work. All of these are part of the copyright infringements, and we will discuss this. Then there are some public licenses which allows you to, or which have certain level of restriction, but it is given for public use. And the kinds of public licensing includes fair use clause. There is Creative Commons and GNU. Then we will talk about trademark infringements. Let's look at the trademark definition. In trademarks, a trademark is a sign which distinguishes the goods or services of one trader from those of other traders. So it is a branding sort of thing which defines the quality of the product or identifies with the actual manufacturer or someone who has produced it under a label of some kind. Okay, so the consumers can identify it with the quality and with the goodwill of that product, such as Nike, for examples. And even in trademarks, there are two kinds of trademarks. One is the label or the drawing or the artwork of it, or the logo of it. which is more to do with, the design work. Then there is another type of trademark which is identified as word mark. Um, and that word mark can be a slogan of some sort that has become famous, or you could say generally in the eyes of consumer, the consumer identifies it with a certain product. For instance, just do it. Okay. These three words are famous for Nike, and Nike has claimed ownership of it as the word mark or the word trademark, along with the design mark, which is another kind of trademark. So there are two different kinds, word marks and trademarks, and the design marks or the logo marks. So, when you're doing your research work and you're using words like just do it, or there could be a longer slogan with, the number of words that sort of consumers know that these words are identified with the kind of product that you're discussing. For example, if it is shoes and it may be another brand of shoes, but if you've used that slogan as something unknowingly, thinking that it is just English sentence, or it is you didn't use it with the intent of infringing trademark, yet you may be liable for using those words unknowingly. And so to know whether or not that's part of the trademark is important. Especially you have to be mindful if you're using it for defining or identifying with the same classification of the product. So if it is shoes X versus shoes Y and you have used the slogan, just do it, then there could be a problem of trademark infringement as well. Here is a list of some of the factors that you have to be mindful of in order for you to not be held liable for trademark infringements. The similarity in the overall impression created by the two marks. So if it is a mark which is giving an impression or some indication that it is coming from the original source, as uh, if it is, for the same classification of goods, yet they are distinguishable. However, you have used it in a way that it appears to have a similarity, then there is a overall impression created in the eyes of consumers. This you have to avoid. Similarities of the goods and services involved. There is these classifications, which has recommended classification of the type of goods, and then there are sub classification of those types of goods that are given a number which identifies with that product. For instance, if it's shoes, then it could be running shoes, it could be, basketball shoes or something like that. But all those are given a classification. So if the classification for shoes is, let's say, 45, the sub-classification could be 45.1 for them, those shoes be uh, to be have a further class for to be further classified as running shoes or basketball shoes and so on. So those classifications, once they appear in the database or the central database of trademark that can be queried at any time, and it is publicly available, you can go online and look for it. And if you find that the classification has similarity, or this is a similar classification of goods for which you are using that slogan or that design, then that could be another factor that would add to your trouble, because now you're using the same classification for the wordings which are trademark protected. Then we've got the strength of the plaintiff's mark. Strength could mean three things. Strength means that how long have that trademark been in business or has been used, um, for the public to identify with their goods. Then you have to also look for the fact that if it is making revenue, it's not like you can apply for a trademark, obtain it, and then not sell the product or not use it or not bring it in front of the consumers. So it has to have that history, and it has to have also revenues coming where it is being actually being sold. Um, and the last thing, the third thing about the strength of the mark will depend on the goodwill, which means the quality of the product. So the strength of the trademark is defined in these three different areas. At the same time, strength also means that collectively, uh, how much of a goodwill it has in the eyes of consumer. Okay. So the overall goodwill impression or the valuation of the goodwill of that mark, trademark can be bought and sold also. So it is, even though it is intangible, but it is tangible enough that it has a value attached to it. So the strength of the plaintiff's mark would mean also in a way that it has a value and a goodwill uh, value attached to it. Then another thing that you have to be mindful about in trademark is any evidence of actual confusion by the consumer. In order for you to make a case in the intellectual properties office or in the legal system, you have to prove that there was a harm done to you, or there has been a decline in the profit, or your goodwill is diluted by ensuring that you are able to prove that the infringer has confused the consumers intentionally or unintentionally, doesn't matter. The reality you have to define and identify it and present it in order for the judgment to have some sort of a damage value um, that they can declare or evaluate. Then we have the intent of the defendant in adopting its mark, whether the defendant has done it intentionally or unintentionally, whether it was by design that their business model was such that they are actually using somebody else's trademarks by either diluting the goodwill through copying those things or selling fake items, or whether they are access that item or sold it from a source that would mean that it is they're selling it at a far less value than what is considered as a standard pricing in the market. Then we've got the physical proximity of the goods in the retail marketplace, meaning that how famous the product is in the eyes of consumer would also mean that you have to prove that it is readily available for the consumers to look at. For instance, if it is sold on the internet, then you've got a very huge consumers base that is looking at it. And if you have distribution channels or retail outlets which are using those goods or selling those goods, would also have an impact or would define the extent of the liability the infringer is held responsible for. Then the degree of care likely to be exercised by the consumer, meaning that let's suppose if we are selling, let's say, our course CIRS, and somebody else is using the same mark CIRS for similar type of um, let's say similar type of services like educational services, then the degree of care that the consumer would be responsible for is to the extent depending on the type of goods. For instance, CIRS is a different course, or it is actually a syllabus which is different from another CIRS. that is in for, let's say, not for research purposes, but for any other purpose. So the consumer, when they go to the website, they know exactly what they want by understanding or by having enough information available for the consumer to make the decision. So it is not like off the shelf good. Like anyone taking the course of CIRS would have a well-defined and well-organized content that would make them buy that product or that service, versus another one which is, totally in a different domain. Let's say for recruiters, that CIRS is for recruiters, then the consumer would be coming from a different mindset. Like they're trying to look for recruitment uh, related certification. So, depending on the extent of information or the knowledge of the consumer to be able to make sense or to be able to identify with the goods for with their specific needs, that would mean that these are very specific or they're individualized, individually separate, and therefore the consumer would not have any confusion. So anything that is well laid out, well defined for the consumer to make that selection as a knowledgeable selection, that is the degree of care that the consumer would be held responsible for. And for that reason, you can be off the hook or would not be liable as much for trademark infringement. The likelihood of expansion of the product lines, which means that the trademark is actually, whether it is brand new or and it needs to be recognized, or it is a brand new product and a brand new logo that's coming out, and the consumers don't recognize it as such, but it has a potential for growth, or you have a planning where you are running a campaign or starting to run a campaign for expanding that product line, that would be something to consider in terms of the brand new goods that are coming out. To what degree or to what level that expansion formula has been implemented, that's what it means with the likelihood of expansion of the products. So, in fact, these are some of the factors, and there could be many more because legally trademarks are mostly contested as a very complex set of within the complex set of rules that are very well defined in the intellectual property law. So there are different layers, and there could be damages which could be punitive, or there could be actual damages, but it is sometimes very hard to, first of all, come up with the goodwill value of something that is diluted or there is a confusion caused out of it. And the fact that a lot of times, the extent of the damage is very hard to calculate in numbers. So that's where the trademark laws have a gray area, uh, and that we have to be well aware of. So, as coming back to what impact trademark infringement has for the researchers, and it is similar to copyright infringement in the sense that it is just two different types of works that are protected under trademark and copyright, yet they have a common framework. So, as a researcher, we have to be mindful of to what extent we can use somebody else's work. Do we have to give credit for it, or do we have to take a special permission of its reuse? Second is, as a researcher, can we build something based on that work, or use a lot of references in order for it to um, disclose the origin of that source? Third thing as a researcher is that even if you are writing something genuine as a genuine work and it has similarities in terms of, let's say, word mark, or it is the same idea, but you are defining it in a different way, that could also um, be something that one has to be mindful of when you are doing or writing researches, so that the originality can be maintained. So that sort of liability is important. And for that reason, you have to have a good understanding of what is going to fall under trademark and copyrights as, to reduce that risk factor. The type of trademark infringements are defined here, and we are going to look at domain names infringements. For instance, they might have the different types of domain name infringement, such as type squatting, cyber squatting, page jacking, linking framing. Linking framing is similar to the copyright infringement we saw earlier. So linking and framing are the same terminologies, but pages jacking, cyber squatting, and type squatting is something we will look at also. Then there is something called meta tags and hidden text. This is more to do with online marketing or using somebody's specific keywords or specific HTML script that has exact same keywords, but you are basically copying and pasting it. So in reality, you're using the tags that hold certain intellectual information of those websites for the purposes of reuse or for the purposes of competing with another site for products and services. And that could be part of the trademark infringement also. Um, it is very hard to prove the trademark infringement in this area of meta tags and hidden text. Then we've got trademark dilution. There could be two types. One is what we call blurring, and the other is tarnishing of the trademarks. Blurring is that you are making it look like the original product or selling it as if it is, um, it has a similar value placed on it, but it is not exactly the same. So that is blurring it. Tarnishing means it's outright copy of something. So you're making, using somebody's logo on your own product. That is outright tarnishing somebody's goodwill. That is directly related to the quality compromise of that product, which is not originally coming from the uh, from the manufacturer. Okay, I'm going to take a 10 minutes break, and then I'm going to show you the centralized database of trademarks to give you a real idea of what is considered word mark and what is considered the actual logo or the design marks. And that central database I've opened already. So when I come back, I will show you that. So let's meet again in about 10 to 15 minutes. I'll see you in a little bit. Okay, I'm back. If you're ready, just let me know. You could still see my screen and you can hear me. Okay, thank you. Now, I want to show you the example. In fact, it is the real database I'm taking you to that you can access easily. This is global database. It's called WIP. I am sending you the link for it. Here is the link. I'll put it in the chat box. And you can do a quick search by brand name, logo, etc. right on the top. Um, so I just wanted to check the word CIRS. And here you could see that it is giving us details of individuals that have filed for it. Like this one, CIRS also means Center International D, whatever. And here they have registered a design mark. See, this is the design mark or the logo. All these are coming as design marks. Okay. And the details are given like it has details like where was it originally filed. So if it is filed in France, maybe it is their own intellectual property office there, but it makes its way into the main database eventually. So because it is centralized and it is global. So this is coming from France and it is giving expiry date and the trademark number right here. And at the very bottom, you could see something that is called NICE class. NICE is an abbreviation of a body that classifies the goods. That's only job is to create an international classification of how the goods are defined according to the numbers. So the NICE classification here is 38, 41, and 42. If we want to look it up, we can check it as well, just to ensure that you know what is included in 38. And the second thing is the word mark. Over here, there is no logo. So this means that it is a word mark, which means CIRS as the initials with the alphabet C that is followed by R, by I, by R, by S. All of these are actually word marks. And word marks can also be defined um, according to the fonts. So if I want to file CIRS in 2 or 3 different fonts, I can do that as well. But that is still a word mark. Another example of word mark, where there is a wording, there is more than a few words. Let me see if I can find it. I don't see it here. This is also a word mark, clinical information. I mean, you can use CIRS and then put it within brackets and write the whole thing that is for use for the abbreviation, the wordings. This is also a word mark. Let me do a search again. Let's use the word internet here. Trying to look for the statement. Instead, let me use something else as well. AIRS. Trying to find the wordings that are more elaborate. See, I'm trying to find where they have written long sentences as word marks. I don't want to spend a lot of time on it, but if I can find it quickly, that would be nice. Airs is spin, for instance. Here they have written airs and then written spin. So these two words together are word marks. Airs and graces are word mark. Okay, so let's just use this as an example. In this one, you could see it says slip, airs, summer walks. So if you use these wordings for something, even if it's like, especially if it is a title of something, then the summer walks is, as long as it is followed by the word airs and slip, these would mean that they are word marks also, even though there are numerous words, and there could be just, real English words also. Like in Nike, it says just do it. Even though it is a casual word we use in our, while we are writing something, we can say that you may be infringing it if you have identified it with the goods that fall under the classification of the number 25. So if we want to look at the nice classifications words, we can actually go there and look it up. So jog ears, for instance, I click on this and I want the details. I can see that, and there are two issues with the trademark. One is that it may be registered, which means that they are actually filed formally and they land in the central database here, or they may be the trademark that is unregistered, which means that it is actually been around in the industry for enough time and it has generated a lot of sales and the consumers relate to it, identify it with the particular goods and services. So that would also mean that there is an ownership of unregistered trademark that belongs to that vendor or that manufacturer. Just because they are not registered, it doesn't mean that they don't have ownership of it. Unregistered sometimes is more difficult to contest, but it is nevertheless considered as the intellectual property, uh, even if it's not registered. So it's called unregistered trademark. And in registered trademarks, there could be pending trademarks, which means that you have filed for it, but it has not been approved yet. So an approval sometimes takes 2 years or 3 years also. So this is the dilemma. So you can work with registered trademarks that are pending approval just because they have been you have applied for it means that you already have assumed or you have been given rights nevertheless on that trademark. But because it is pending, then there could be a little bit of a technicality there that you will have to prove to the judge. But when it is approved, it is called registered trademark. So where you see the round circle next to some statement or the logo that says C or has C inside of that circle, that means that the copyrights are pending, yet you have filed for it. But if you wrote R in the circle, that means that they are registered trademarks. Okay, so that is the only difference. Let's get back to the slides now. I'm going to open the book as well. Now I'm going to take you to page 456. If you can mark it as an important page for this chart that you're viewing right now. You see this chart here? In this chart, we are going to talk about the patentability or the patents of that are also the intellectual property. In this chart, you could see that it is got these columns, and at the top, they've written things like requirement for patents, what it means to be patentable. So requirements for the patents are 1, 2, 3, 4, and 5. You should read this or keep it as a reference. This is the requirement for the patent. Number one requirement is that the innovation is patentable, meaning that it is something new that you have created. It is not built on somebody else's technology or somebody else's intellectual property, and it is something brand new. So there is to be a factor of innovation in it. What is considered patentable in terms of innovation and what is not patentable, these are also identified here. So if it is an innovation and that can be patentable, examples are new products such as toys, appliances, tools, medical devices, pharmaceutical drugs, and there could be uh, different things. A process is also patentable as long as it is innovative, it is scientific, or it has a technology which is brand new built into the process. So not every process is patentable, just know that. Such as manufacturing process or an industrial method of process. So if you have improved on production of something in terms of manufacturing, that is innovation, and not by applying the similar technology, but applying some new technology in the process. So that is patentable. But what is not patentable here is mathematical algorithms or models, um, which means that the algorithms, for example, or the software that we write is not patentable, yet they are, you can put a copyright on it. So they are copyrightable, but they are not patentable. Artistic creations are not patentable, but they are, copyrighted. Software is patentable as long as it is brand new or something like, let's say, the JavaScript that you have used. The JavaScript is in a public domain, but how you have applied it will define whether the software is patentable or not, and so on. In the second one, you could see that it says that the innovation is new. That means novelty is the actual word to use. Innovation, you cannot patent something that is already publicly known, as it would be unfair, whatever. The test of novelty is important. The test of novelty is assessed as at the date you file your application for the patent. For this reason, if you intend to disclose, so there is a factor of timing also. So if I have placed or I have applied for a patent, let's say few months before somebody else applied for the patent of similar things, then the date would be the factor, like who applied it first. Okay. The third factor in making it patentable is the innovation is inventive, meaning that you have created something brand new. Basically, it's defining what is considered new. This requirement of an inventive step relates to obviousness of the new product, process, or invention. It is obvious to a skilled person. It is not, if it is obvious to a skilled person, it is not patentable. Meaning that if it is a process or a product or a novelty that the skilled person is already familiar with, or somebody else could apply the same at the same skill level, could apply for patents on something which would mean that, if you are an engineer, for instance, and you are using the same methods and using the same formulas on creating a similar product, it may not be patentable, meaning that it is well known. It's just the process that may have been manipulated a little bit, but the skilled person recognizes it as if those are standard processes, but the formula is actually manipulated. So that would be mean that it is not as inventive. The innovation is useful, meaning that it is not something which is not going to do any good for anyone, or if it is an innovation that is that cannot be used by anyone for any reason, for convenience or for commercial use, or if it is not identified with making somebody's lives better, or there is a factor where that innovation is not tangible, or it is not something for which you could place a value for its usefulness, then it is not patentable. The innovation must not have a prior use. Let's see. So this is the fifth one. If you have been selling the product using the process in your business, or if you have licensed it, this prior use disqualifies it from being patentable. So basically, whenever you are filing for a patent, it has to be something which is brand new. So the newness of it, or an idea which is totally brand new, a concept that is discovered, um, uh, you know, uh, prior to being used, and it is filed for before it is being used. That is another condition of uh, something to become patentable. Now I'm going to talk about the trademark infringements. We will do copyright infringements later. I just want to finish up the trademarks first. So let me. So there is one type we call type squatting, which means that you're going to make the domain name appear. See, domain name is an intellectual property to the extent where the domain names have a meaning or has a validity for understanding an idea, or it is a name which is famous enough or has um, extensive recognition by the common consumer. So the more famous domain names, let's say PayPal, for instance, which may have a slight difference in spelling, and whoever is using that domain name is, let's say, adding a word or changing the spelling of it to make it appear as if it is coming from the original source, or it is the original domain that is recognized for its goodwill, then there could be a type squatting infringement, and it would be falling under the trademark infringement. So if somebody wrote PayPal with a .co.com, or PayPal with Y missing, that could be an infringement. If you wrote PayPal idea or PayPal payments together, that could be an infringement also, because it makes it look as if it is coming from the original source when it is not. So that is type squatting. people actually do that intentionally and hold those domains under their name as their registered property and then resell it. So that is type squatting. Um, then there is cyber squatting. Cyber squatting means that supposing if it is Cisco systems, which is well known for network devices, and if I got or if I got the domain name, let's say Cisco for less or Cisco systems products, that would also be cyber squatting, which means that I'm buying those domain names which gives a common idea that it is coming from the original source, and at the same time I'm using the word Cisco in it when the original Cisco is cisco.com. You don't have to write Cisco systems. So this is cyber squatting, where you are actually buying those domains that has the original manufacturer's wording in it, and people buy those domains, and then when the original owner gives them a warning or tells them to not use it, you would give an offer for them to buy it from you, and therefore you can make money out of it. So not to get into the litigation, but the general idea is to sell it to reduce the cost on for both parties for litigation, and rather have them pay you a little bit of money to sell it to them. That is cyber squatting. Then we've got page jacking. Page jacking is when you are designing a website to look like as if it is from the original source. For instance, if it is a PayPal web page and you've designed it, make it look like the original, it's coming from the original source or the original domain when it is not, that is page jacking. Then we've got linking. Linking is, there is a distinction between linking and framing. Now, linking and framing are basically two type of technologies. First of all, linking means that on your website, you have actually placed somebody's picture or somebody's content, which is not totally complete, but it gives an idea or gives the notion that it is actually originally coming from the site itself. When the consumer clicks on it, it takes them to another website. So what that does is that in the eyes of consumer, it is thinking that the function or the website itself is generating subsequent pages that is you are taken to eventually is coming from the same domain, but actually it is linked to another website. So when you're doing funnel marketing, a lot of marketers or digital marketers do linking on their websites, and they take you to another site, and then when you click on it, it takes you to yet another website, which somewhat is giving a notion that you are still on the same domain. When you look at the link on the top, it is taking you to the different ones. That is linking. Then we've got framing. Framing means that on your website, you have, actually, this is a technical thing. You create a box, or you sort of have a demarcation which has a border to it. And in that box, you are displaying the content which is linked to another website, or it is running on another website, yet it is displaying on this particular domain where you are at. So the frame that is created, which is responsible for generating that content directly coming from the third-party website or somebody else's original website, that display within that technical frame that you have created is called framing. And this framing is also a trademark infringement. It could also be, we use linking and framing in copyright infringement as well, with the same idea. except that when you are displaying things like video, for instance, within the frame, or linking it with the videos that is displaying somewhere else, but not on the same website, that both can be considered as copyright infringements, where the content is originally copyrighted. And there could be a technology part which is displaying within the frame, or it is linked to that, might be trademark protected. So it is also a kind of an infringement which is used, or the terminology is used for trademark infringement as well as copyright infringements. Then there is meta tags and hidden text. So what happens in this is that, sometimes uh, the designer of the website would start to copy the HTML code, especially the information within the tags like keywords, for instance, and other similar kind of tags which contain certain keywords that are identified with the products and services of that particular site. Those copying of the code, which is not visible to the common consumer, but it is actually picked up by the indexing system of the search engine that reads it, would think of it as a similar or the same website. And therefore, when somebody is typing some keywords in the search box, the similar sites would start appearing, or the original site goes lower in ranking, and whoever is using those hidden text or meta tags of its competitor, it is coming as priority in the ranking system of your search results. That intentional manipulation of HTML codes and the information held in those tags, when they're copied and it placed exactly um, on this particular site for marketing reasons, it is also a kind of a trademark infringement. Then we've got trademark dilution. Trademark dilution means the tarnishing or weakening of somebody's goodwill that is attached to the branding, maybe a logo or the word mark. So what it means by definition, trademark dilution, it means the weakening of a mark through unauthorized use. Okay. Um, this differs from trademark infringement, where it only applies to famous marks that causes dilution of distinctive quality and can occur even if the consumer is not misled. Meaning that it wouldn't matter if it is intentional or unintentional, as long as it has a similarity that would look somewhat similar to the trademark and it falls within the definition of trademark infringement, it would mean that you are weakening the goodwill or the value of that mark, or the word. It could be a design or it could be a word mark. So the dilution would mean two things. One is that it could be blurring of trademark, or it could be tarnishing. Blurring is by definition weakening, really weakening of the trademark, intentional or unintentional. But as long as it is happening where it is, uh, some consumer, and the taste and the test for the trademark dilution is that if the consumer is searching through keywords something to do with anything that comes under branding, let's say guess is the branding, and the word you have used is guess watch. So with guess watch, you would probably get some other website that is using the branding like guess watch as a word rather than a mark, but it is bringing the website which is selling similar products, but it's not the original site of guess products. then it is blurring the trademark, it is weakening it, because now the consumer is comparing prices and similar watches with the original branding. So that is blurring of trademark. When you're tarnishing it, that you're outright copying something and selling fake products under the original brand name, and therefore you're tarnishing the goodwill. When you're tarnishing the goodwill, the liability is much higher than when you're blurring somebody's trademark. So, clear so far? Okay, good. In the slides that I am showing you now, I just want you to um, be able to look at these as examples of cases that are called case studies, and you would get these in the exam um, on some of the topics. So I'm just briefly going to ask you to go through these, if possible, over the weekend and see if you can answer some questions based on what we've covered so far. There is a case study in the slides that are already uploaded, and they are like PDF files. You could see that we have case studies on copyrights. We have link copying, which is another kind of infringement on trademarks we just discussed. Piracy, I'm just going to discuss it now. Plagiarism. Plagiarism is kind of a copyright infringement. Then we've got defamation. And the last one is e-commerce related. Okay. E-commerce is very basic. It's a common knowledge, so you wouldn't have any problem. But for copyrights, you need to apply your knowledge that you've gained in this lesson today. So these are 1, 2, 3, 4, 5, 6 of these. And in the exam, they could ask or put you in a situation to identify or to give answers based on a case that is, briefly stated from any of these. Usually there is just one case study because of the time restraints. They don't give you a lot of questions um, on this, just one question, but it is coming from 1, 2, 3, 6 of these slides. Just to give you an example, like we just did copyrights. It is talking about a case here, and it is briefly stated in 3 paras. You have to read this carefully and then you answer the questions on the right hand side. So in the first one, there are 4 choices. Like what is the copyright infringement issue in this scenario? So you, from these four choices, you have to select only one answer. Okay. Uh, you want to quickly read this, Tristan? It's on the left. Just just to get an idea, and then answer. Let's answer some of these questions. So here, Ronald is a student, and there is a course book that he is getting copied from a shop nearby upon the request of a professor of the university. Um, and I guess the professor assumed that because a lot of students don't have the money to buy the original work, original book, it might be okay to make a copy of it. And the professor sent Ronald to do it for him. The student realizes that the store owner is completely unaware of the risk of this task and hence tries to explain to him the danger of copying another's work without permission. So the student here is aware of it. Ronald knows that it is not a good thing to copy somebody's intellectual property or to make copies of the book. But the shop owner refuses to believe that there is any danger in such an activity. The shop owner who is making the copies is only interested in making money out of those copies. So he didn't care and he made the photocopies. Sometimes there is a misconception that any work that you can copy which has to do with learning or which is to, basically is for educational purposes, that is commonly stated in the general public licenses as okay to do. But in this case, one cannot justify that you could make copy of a book itself that has a value attached to it. Um, so assuming that it is okay to reprint something or to make copies of something which is educational is not going to um, absolve the copyright infringement. The student is well acquainted with the professor and feels uneasy. However, the student is well aware that it is his responsibility to bring this matter to the attention of the university. He shares this issue with a friend, and the friend advised not to keep silent about the matter, although Donald couldn't help feeling guilty on this one. So tell me, if you have read this situation, can you think of a better answer or best answer for the first question? Here it says, what is the copyright infringement issue in this scenario? Which could be the right answer, in your opinion? One. Agreed. I agree totally. So these are not difficult questions to answer. And the second one, it says, which right of the copyright owner is violated in this scenario? See, I told you the three liabilities: direct infringements, and vicarious, and so on. it says which right of the copyright owner is violated. The public display right, the right to reproduce work, the public performance right, all of the above, I would think. That's a common sense answer. So 4 is the answer for number 2. What do you think about number 3? This might be a little bit tricky. 3 and 4 is something that one has to think about, I guess. Like the type of liability. Is it direct or not? And then who is responsible for direct infringement? Okay. Okay. One thing about direct infringement is that anyone who acts upon something to get done would have the highest level of responsibility or would be the direct responsible. So if the copy shop owner has made photocopies of a book, he's directly infringing. If somebody has propagated the idea or given directions to do something that is wrong, it is the act of actual doer who is directly responsible for it. Just directing someone to do something may not be enough evidence for direct infringement. So anyone who act upon the advice, in this case, the student, from the direction by the direction of the professor, is also somewhat has the direct liability, but more so for the person who is actually doing the act, like the one who is making copies of it, in my opinion, would be the direct infringer. But it is just my opinion. So I think number 2 might be a direct infringer. In 4th, who is responsible for contributory infringement? Now here the student is responsible also. Um, I mean, question number 4 is very difficult to answer because contributory. Let's go back and look at the definition of what is contributory one more time, because this is where I find that most of the student give incorrect answer. So I'm going to open the book and I want to look at the definition and we can see it together. This type of copyright infringement occurs when the liability or the responsibility of the copyright infringement is imposed on someone who has not involved in the infringing activity but has contributed to an infringing act of another. Knowledge of infringing act as well as material contribution to it are two important factors. So what are the two important factors? Knowledge of the infringing act as well as a material contribution to it are two important factors to contributory liability. I think everybody would have the contributory liability by definition. So I think the student, where it says, if you read this on the left, it says It says the student realizes that the store owner is completely unaware of the risk of this task and hence tries to explain to him the danger of copying another's work without permission. So the student seems that he is the only person who is well aware of it, who has, who has full knowledge that it is an infringement. Yeah, I know there is always a controversy here whenever we are dealing with this case law. That's why I thought that we would do it together. But it is just the opinion, and we can only look for the best answer. And sometimes the information on the left hand side is, or the or the paragraphs are not as complete. So there could be this situation where we could have different opinions. Yeah, I am no expert, but I took, yeah, professor would be the only one at fault. But what if the professor was not aware that if it is, or the professor assumed that if it is for educational purposes, it may be okay for the book to be copied. So he may not be aware of it, but the student was, and student, and this is what is defined in this case law, um, which only says that the student was aware of it. And it seems that the professor, or it is assumed the professor was not aware of the infringement. It could be an undue burden, but by the definition of how we are looking at it from whatever little knowledge we have, uh, that's given here in this excerpt that is in 3 paras. The only person that seems to be aware of the infringement is the student. So that's what I'm wondering, whether the shop owner was aware of it or not with the limited knowledge, or whether the professor was not aware of it or unintentionally thought that it is for educational purposes and therefore it might be okay. So we uh, and then if you look at the definition, it says the contributory infringement is on someone who is well aware of it or aware of the infringement. And here the student is the only one who is aware of it. So that's why I'm wondering what could be the best answer. Only the examiner would know. So I'm just letting you um, be aware of where it could be, there could be a confusion, even for me and for you. In any case, let's suppose your answer for the first one, and I'm just going to mark it and we'll check it later. I'll see if I can get hold of the examiner to see what the right answer is. Because I know this came in the exam, so there is definitely the answer that is actually given there. So I will highlight this as your answers, and then we'll check it later. What right of the copyright owner is violated in this? Okay. I'm just marking the answers that you gave, not my answers. Um, University, I think for number 3, it was the university professor. And what you say for the fourth one, you say the university professor. Okay, number 4. Okay. And in your opinion, can this be qualified as fair use, you think? Obviously, I would say no. It's a simple answer is no. So I will just mark if you agree. Mm, I see. No, yeah, I understand what you're saying. If it is not the whole book, maybe few pages, it should be okay. But right now, I'm just assuming it is the whole book. That's what it is. So if it is the whole book, then the answer should be no. Okay. So I've marked these answers that are coming from you. Um, you want to do one more because we've got last class on Monday where we can, actually complete some parts, including jurisdiction and spamming and few of those things. So I can leave it for Monday, but let's just do one more example, case study number 2, and this way we'll finish up with the copyrights and trademarks. Let's read this. One day, the publisher of the magazine was searching the internet when he suddenly came across Larry's website. He sees the links that Larry. Why? Okay, so if you read this part, you can see what's going on here. Seems that Larry, who is a photographer, is very passionate about the pictures, the photographs he takes on wildlife, and he has his own website also. And he's actually working for, or you could say, has some contractual obligation towards a magazine called Natural History, and he's selling those pictures, or maybe is responsible for handing these over exclusively for the use in Natural Heritage magazine. Yet, even after the publishing by Natural Heritage or having the ownership or the rights to those pictures, uh, Larry had used it on his websites, and therefore there is an infringement of copyrights. So let's see what the first question says. It says, what is the copyright infringement case in this situation? Number 3, yes, I agree. Number 3, it is obviously linking. You're linking it to the magazine. So it's linking here. Let me also mark it as your answer, which I also agree to. So this is the correct answer. In the second one, it says Larry is responsible for, again, the same thing: direct infringement, contributory, vicarious, and so on. So Larry is responsible for what, which type of copyright infringement you think? Yes, I agree. One we can both agree on. So I'm going to mark this. Sorry. Now we are on number 3. What is the linking related to? What is the linking related to copyright in this situation? Larry provides linking related to copyright. Number 1 provides links on his website to copyright protected images. Correct. Yeah, you're correct. Also, on this one, Larry argues that copyright images belong to him. Yeah, this is the identification of copyright infringement. So number 1 should be the correct answer. I agree. Um, Number 4, what can Larry do to seek permission from the publisher? Sometimes you can also talk to the owners for using the intellectual property, and we have done that previously, and we do it off and on because of our educational material that we use. So sometimes we have to borrow some of the work from somebody else. And at times we have to make a formal agreement, or we can just inform them and they would give a consent. Uh, Even on a chat, it should be sufficient. So there is this just talk to the publisher thing that I think works also. You can also sign a linking agreement, or you can go to the court if you feel that you are on the right side of, or there is some flaw in the contract, or there is some understanding that the court would give a favorable decision in your case. So all of the above, in my opinion, can work. Um, so I think for the fourth, my answer is all of the above, but I would. Okay, so you have what, 1 and 4? There has to be only one answer, unfortunately, in multiple choice. So you're saying 1 and 4 on the fourth one, or I said, okay, one, okay, number 4, I agree. So all of the above would work. Okay. So we both agree on this one. I'm going to mark it. And then we have the last one. What is the benefit of linking? Links allow quick and easy access to information. Links appear nice on the web page. Links allow secret access to other websites. I think all of the above would be some of the benefits, even though they're infringed trademarks. But these 3, 1, 2, and 3, could be the benefits, all of the above. I'm sure you'll agree with number 4 here. If not, you can tell me. Okay, I think we can also do case study. We can just finish up as many as we can so that we are done with this. You don't have to put any extra effort during the weekend. You can just lay easy. So let's just see if we can finish it quickly. And it is moving quite fast. So let's look at the piracy as copyright infringement. Piracy can happen both for trademarks and copyrights. So let's look at the cases here. Piracy is like copying the original work or reusing it, republishing it without, the permission of the owner and so on and so forth. So piracy is a term we don't need to define extensively. We have a common understanding what piracy means. So let's just read this one. Justin is a division head of Stewart Corporation and audit firm of 80 staffers. After attending the annual staff meeting, he was told that his division has a very high expenses. Okay. Yeah, this is quite a common situation with software, especially the ones that are very expensive to use. So small companies, small businesses, it's not very, it's very common to find this situation where there is one license and everybody is using that software on their machines. Sometimes the software can be placed in a centralized server and there could be several users that are connected to it. They can actually access it from a central location. So this is where the piracy happens. Piracy basically is use or unauthorized use of the software, um, or if there is a license that is clearly defining how to use this software or the commercial value of it or the price that you have paid for it, to what extent you are um, able to uh, to apply that or to use it. Um, in the first question, it says, what is the copyright infringement activity that they have carried out? We didn't do phishing or link. We did hacking. Okay, hacking we know. Phishing, by the way, is simulating as if you are using the application or the software in this case, which is mm, original, but it is a copy of it. So that is phishing. But phishing can be applied in different. Phishing simply means making it look similar when it is not original. So anyway, you have answered the first question. Number 3. Yes. Agreed. See, this is a numbering issue here. Let me fix this quickly. It's number 2. Okay, now it's all right. Accusing of piracy in this scenario refers to. Correct. See, these are very easy questions, isn't it? Like some of them are, logical. Um, what is the type of copyright infringement the company is liable for? Third one is requires a little bit of thought. So it is the whole company that is liable. So all those employees, um, you know, would fall into the same, into the criteria. Um, and the infringement is known, I'm assuming that they know that they're doing it intentionally within understanding that they bought one license and then everybody is using it. So this is a direct infringement in my opinion, or you can give me an answer for this. What do you think? See, for direct infringement, there is a very high onus of liability on the company. Yes, I agree. I agree. So direct infringement here would be the best answer. Yes, Justin is the head of the company and yes, responsible for anything that goes on under his nose. And Justin is well aware of what he's doing. He's basically trying to cut cost and directly responsible for it. But the company is also directly responsible in a way because a steward is representing the company, right? And possibly is indemnified as well by the company. So indirectly, you could say that the company is responsible. Then we've got who is the main copyright infringer in this? Justin, you think number 4? Is that what you said? I'm sorry. Yes, correct. What is the risk of using pirated software according to the above situation? A lawsuit can be filed, compelled to pay significant fine, potential private and public. All of the above, I think. When all of these things can happen, so defamation and e-commerce we haven't done, but the last one, plagiarism, falls under the copyright infringement. So we might as well finish this example also. If you are up to it, we can do that. Okay. I think it is more interactive when you are looking at these case laws and case study, and it makes it more interesting because otherwise, everything else we do is theoretical and it's one-sided. I'm just, explaining things. Um, so yeah, it is not as boring. So let's look at the plagiarism. Todd is a senior. Todd is a senior at university and only one semester to go prior to graduation as part of his course submitted at the end of the semester. This is course. Okay. So friend, the Todd is liable. Uh, So in the first question, if you're done reading, the obvious answer is plagiarism, in my opinion. Okay. What are the unlawful acts he has committed in being liable for plagiarism? Use direct quotation in paragraphs without citing references, use both library resources and online material. He had written the paper in a draft format. Number two, I think, correct. So mark this as the correct answer. What are the best practices that Todd may have followed in correcting his mistakes? He uses quotation and paragraph with proper acknowledgement of the source. I think number two. So I'm just wondering if there was something that we took from the internet, which we found through the link, or there is a link to that page where the content is used from. Do we have to put the entire link as a reference, or there are certain information that has to be mentioned along with the link itself, or the link is sufficient as a reference? I have actually found out that three things has to be there in putting the acknowledgement or the references, and link may not be as sufficient because we don't know the origin of the link or where that information originated from that is used on that linked page. So the name of the author, the date, or the title of that document, these three things we have to mention, even though we can, put the direct link there as a cited reference to where to go to or where you collected it from. That's not sufficient. So if it is a formal writing, if it is academic paper or something for which we need to give acknowledgement, it has to have these three things: the name of the author. Sometimes you need the date also, but that could be an added thing. Uh, then the title of that content page, or the title of that subject matter, that is important. And then the where it was published. So these certain informations are important, that needs to be added to your references. So link is not generally enough, and it does not signify or identify with the original author. Okay. Just have to remember that. Yes, APA style is one thing, but that is academic side of it. But let's suppose I'm publishing something as someone who is not aware of different styles of how you are going to show the citation. So as someone who is not aware of it, and I just need the few of the elements which are necessary elements to identify with the original source, I would have to make sure that more than the link itself, I have to mention that information. So what could have been the strategies for the Professor Williams had explained to Todd? What could have been the strategies that Professor Williams had explained to Dot? Okay. So here is another question. Put within quotations everything that comes directly from the text, paraphrase, but be sure not to rearrange or replace the words. Check all paraphrasing. I think all of the above should be the best answer for number 4. Do you agree? Here it is. Okay. Now we are down to the last one, number 5. It says, what could have been the, yeah. Number 4, okay. For number 5, easy answers, eh? So for, and by the way, just so you know, and to put it on record, like if you have questions like these in the finals, and supposing there are these 5 multiple choice questions, and out of 5, one of them is incorrect, then you will be given the credit for 4 out of 5 to be correct. And only one wrong could mean that percentile or that percentage of the whole is striked as the marks lost. So if it is, say, 1 mark for the multiple choice altogether, then 1 mark is split into 5 parts. So 1 divided by 5. And if one of them is incorrect or 2 of them is incorrect, you will be, the examiner or the system will be deducting only that percentage or that part of the incorrect answer and would give you credit for those that are correct. So it's not a big loss as far as the marks. Before it used to be that all have to be correct. Now they have, they're doing it according to the fraction of the correct answers for, number of multiple choices. And I think these are the ones that we would think that relate to trademark or copyrights. And the other 2 case laws, as defamation and e-commerce, we can do on Monday. Okay, once we are done with what could be the different situations in e-commerce for that we need to be aware of, or the legalities of e-commerce transactions, or something that you would have to deal with, especially when you're doing subscriptions or you're buying something online. And then defamation could be a libel or slander. So there are only 2 different kinds. And we would cover that also on Monday. So we'll finish up everything on Monday. And that would be the end of CIRS course for us. And after that, we can keep another session based on your needs, specifically for the exams. Other than that, we are finished with it. Okay, I'll do the math here. So let's suppose this is the calculator. I'm going to divide 1 divided by 5. So if there are 5 questions, each question would be 20% of 1. So basically, if 2 of them are wrong, you would lose times 0.2, 20% times 2 is 0.4% of 1. You will still be able to get 0.60 or 60% of the marks, and 40% would be lost because 2 of your answers are incorrect. And because we are using 20% as a division of 1 divided by 5, because there are 5 questions. So 1 divided by 5 would make it 20% that's allocated to individual questions. Okay. All right. So let's call it an evening, and we conclude this session today. I think it was fun, was not as boring. Now we'll just finish up one more session on Monday, and wish you a great weekend. And I hope to see you back soon. Okay, you too. Take care. Bye bye. Bye.